Does every step in Adam's IDAC timeline have a lawful foundation? What the law required versus what IDAC actually did. The quantum leap of Col Padayachee. The focus is not presently on what IDAC eventually discovered. Whether the accused are guilty, that is not what the focus of this is all about. Or whether the prosecution will succeed, we don't know. The magistrate may find them guilty of something that we do not know in these files. The central question is what authorized IDAC to exercise each power on the timeline. It is important to understand this timeline step by step, date by date. Early in October 2024, Fidel Adams says he anonymously received information concerning alleged fraud and corruption within crime intelligence. He says he received a brown envelope underneath his door. What information did he receive inside those brown envelopes? And from who? And what objective grounds was that for? Why did it go to Adams? Why didn't it go to another MP? Well, I don't have an answer for it. Then we move on. October to November 2024, Adams opened and caused complaints and criminal dockets to be opened in different SAPS structures in two provinces. That is Cape Town and in Gauteng. Why were they substantially overlapping complaints distributed across several police stations instead of just filing his complaint in one police station and manage it from there? Why? Late in 2024, correspondence was sent from the Minister of Police, Senzo Mcunu's office to IDAC. The precise date is still to be confirmed when they come in and testify. The correspondence was not itself the Section 27 affidavit. What legal consequences, if any, did that correspondence have? Those are questions that need to be answered by Senzo Mcunu and his favorite subordinate Nkabindi. We move on. 6 December 2024, a preliminary investigation was reportedly authorized under Section 28. This is a major red flag. The only confirmed Section 27 referral had not been signed. What matter was placed before IDAC and what authorized IDAC to investigate something that does not have a Section 27? December 9, 2024, SAPS hands over all of Adams' dockets that he had filed all over the country. Here is another red flag, a major red flag. Under which statutory or procedural power did IDAC request, receive, or assume control of the dockets before a Section 27 referral existed? Where did IDAC get the powers to go and retrieve dockets from SAPS? We move on. 6 January 2025. Adams signed the affidavit relied upon as the Section 27 referral. This is the date that Adams signs this referral. Did the affidavit satisfy all three requirements of the Section 27 A, B, and C? or did it merely identify suspicions? We are going to go into details about that when I'm done with the timeline. January 30 to May 2025. IDAC continued gathering information under the preliminary investigation process. Was this a lawful preliminary investigation? Was it being used to find the reasonable grounds that Section 27 required on the outset? What basis did they have to be doing that preliminary? Because it's just so confusing, guys. It's so confusing. Anyway, we're still on the timeline. 30 May 2025, a full investigation was authorized under Section 28(1)(a). What evidence supported the transition from the preliminary inquiry to a full investigation? In June 2025, a new Brooklyn criminal docket was registered. Why was a new docket required rather than continuing with one or more of the 7 original dockets that they retrieved from the SAPS? So they took the 7 dockets, dumped them on the side, and then went and created another docket. So now we have 8 dockets. June 26, 25, the arrest took place of Lieutenant General Khumalo and 6 of his team members. The arrest occurred less than 4 weeks after the Section 28 full investigation was authorized. What evidence was gathered during this period that was actually lawful or that supported the warrants and charges? The immediate difficulty is that on the currently established timeline, the preliminary investigation and the acquisition of the 7 dockets preceded the only confirmed Section 27 referral, the prescribed referral pathway. In a matter reaching IDAC through Section 27, the process should ordinarily be understood as follows. A person has reasonable grounds to suspect a specified offense. The person must already possess grounds capable of supporting the suspicion. Step 2. The matter is laid before the investigating director under Section 27. This must be done by affidavit and affirmed declaration. Step 3. The referral is assessed. IDAC director must determine whether the Section 27 requirements are satisfied. A specified offense is implicated. The matter falls within IDAC's statutory mandate. Step 4. A preliminary investigation may be authorized under Section 28(13). This stage may be used to clarify or develop a matter that is already lawfully before IDAC. Step 5. A full investigation may be authorized under Section 28(1)(a). This requires a proper evidential and statutory foundation. The central chronology question is therefore, how did Section 28(13) come before the only confirmed Section 27 referral? Okay, so now let's actually read what Section 27 of the MPA Act says. It says the laying of a certain matter before the investigating director. 27. If any person has reasonable grounds to suspect that a specified offense has been or is being committed, or that an attempt has been or is being made to commit such an offense, or he or she may lay the matter in question before the investigating director, Andrea Johnson, by means of an affidavit or affirmed declaration specifying A, the nature of the suspicion, B, the grounds on which the suspicion is based, and C, all other relevant information known to the declarant. Section 27, therefore, requires more than the existence of a suspicion. It requires the suspicion plus the grounds supporting it plus the other relevant information known to the declarant. The reasonable grounds must exist when the matter is laid before IDAC. They cannot be supplied retrospectively by evidence found only after the investigation has begun. In layman's language, IDAC's mandate is very narrow. IDAC is not a police station. So if you have a suspicion of anything, you can go to the police station, and the police station has the mandate to investigate anything and everything. But IDAC parliamentary mandate is very small. So when you go there with a case, you need to have at least done some investigation on the case, and you need to give them the evidence that you have or any annex charge that you need to attach, like pictures, videos, things like recordings, things like that. You have to give everything to them for them to assess if they can take your case. Otherwise, it goes back to the police station. Adam's affidavit, specifically, I am only going to zero in on paragraph 4 of his affidavit, because this is the paragraph that has led to 7 of Lieutenant General Khumalo's team members to be arrested. Adam states that he suspects General Khumalo, General Madondo, General Lushaba were manipulating the procurement processes. He suspects appointment and promotion processes were manipulated. A young woman previously employed by BMW was appointed as a brigadier in the TSS, the Technical Services, within crime intelligence. No colonel employed within crime intelligence was considered suitable for the post. There were numerous questionable appointments. He's saying this is not the only one. Appointments were awarded to persons loyal or close to individuals named. Appointments as Secret Service offices around the country should be investigated, and these offices were likely being used to launder crime intelligence money without detection. So all of this, all of his affidavit, let me say, has no documents, has no appointment records, he has no witness statements, has no supporting material, he has no videos, photos, nothing, no evidence, no annexures attached. So paragraph 4, against what section 27 that we just read, it says the nature of the suspicion. This appears to have been identified in his affidavit. Adam suspects manipulation of procurement, manipulation of appointments and promotions, favoritism and loyalty-based appointments, money laundering through Secret Service offices. So section 27A, therefore, appears to have been met. So we give him a green check. Section 27B, the grounds on which the suspicion was based. Paragraph 4, which is all that I'm going to focus on, does not explain how Adams knew the recruitment process was manipulated, which recruitment rule was breached, why the appointment of a person previously employed by BMW was suspicious, who said no internal colonel was suitable, what made appointments questionable, how loyalty and personal proximity was established, or what facts linked the appointments to money laundering. The statement that a civilian previously worked at BMW was appointed as a brigadier describes an event. It does not, without more, establish reasonable grounds for corruption, manipulation, and money laundering, and the precca that Padayachee is talking about. So, on the face of it, I seem to sound like Commissioner Valoy. On the face of it, paragraph 4, section 27B of the NPA Act was not satisfied. So we give him a red X. And then we move on. Section 27C, all other relevant information known to the declarant. The affidavit does not disclose the name of the woman concerned. He just says a BMW, lady from BMW. So there's no name on the face of the of that section 27. The date of the appointment is not there. The advertisement or post requirements is not there. Her qualifications or employment history is not there. The interview and selection records are not there. The identities of alleged overlooked candidates is not there. The names and details of other questionable appointees is not there. The identity of any source, any financial transaction, because Padayachee is talking about gratification. So where are the financial records that this girl benefited between her and Lieutenant General Khumalo? He doesn't even disclose any secret fund record. There are no witnesses or any document supporting the alleged allegation of money laundering. No annexures were attached, no recordings, no videos, no pictures. On the face of paragraph 4, section 27C was not met, so we give it a big red X. The section 27 effectively does ask, show me why IDAC should even consider commencing an investigation. Remember, I'm going to repeat this again. IDAC's mandate is very, very narrow. It's very small. They are only supposed to investigate complex crimes, complicated financial crimes. And that margin has been narrowed because they are not a police station. So people cannot just be walking up to IDAC and ask them to investigate anything. You must prove this 27 A, B, C, all of them, all 3 of them, not one of, all 3 of them have to be satisfied. It does not say, I suspect corruption. Please investigate until you find reasonable grounds for me. You need to come to IDAC with reasonable grounds and evidence. Paragraph 4 of Adams' affidavit tells IDAC what Adams suspected, but does not adequately disclose why he suspected it or what other relevant information he possessed. The referral, therefore, identified the suspicion but did not on its face supply grounds and relevant information required by section 27B and C. And I'm trying my best not to go into IDAC's motive. I'm going to stay professionally on this recording. So this is how Padayachee, the colonel with 40 years experience under his belt, he came with a very impressive resume. And so this is how he applied the section 27 A, B, and C. Listen to him.
The section 27 referral, I don't see it.
Oh, you don't get to see it?
I don't see it. As I said, and to go back, my end where I come in is the designation 2813 that comes up to say, I am now appointed on this preliminary investigation. Management makes a decision, authorizes it, it comes down, we comply.
Mr. Padayachee has never touched a case docket in his life.
Investigative thinking versus constitutional thinking. This is the exact thing that Col Padayachee is lacking. Investigative thinking says we investigated, we found evidence, therefore the decision to investigate was justified. Constitutional and statutory thinking says no, stop. What information existed in day one? What exactly did IDAC know on day one? What statutory threshold applied? That is Section 27. That's what they should have applied. Was the threshold met? Was Section 27 A, B, and C, all of three of them met? What authorized the Section 28, the preliminary investigation? What authorized the next exercise of state power? IDAC has a lot of power. IDAC has the power to investigate, prosecute, or maybe investigate, arrest, and prosecute you. The fact that an investigation later produced evidence does not by itself establish that the investigation had a lawful foundation when it began. In closing, the central principle to Section 27 is that there is no hindsight, no retrospective justification, no quantum leaps. State power must be justified by the facts and lawful authority existing at the time it was exercised.